Tim, welcome to the show. You must be feeling this morning very pleased with yourself, and rightly so.
I don't know if pleased is the right word. There's a degree of satisfaction that we've got to this point. After the Gone Fishing podcast came out in 2018, and we first started looking at this case, it wasn't clear how long it would take to get to this point. Unlike some of the other cases I've worked on, there were additional complexities and challenges with it, and the pathway to these exonerations wasn't that clear at the start.
Take me back to Gone Fishing, because it was a Radio New Zealand podcast. I think Stuff were involved in it as well. How did that come about? What was the issue? Because Gail Maney had always protested her innocence. She'd been in jail. She came out. She was finally released from prison. Stephen Stone was still languishing there, been denied parole. How did the Radio New Zealand podcast in 2018 come about?
Well, I mean, that's not really my story, but Amy Maas was a journalist at Stuff at the time, and she was, I know, in prison on another matter, and she met Gail Maney, who was in prison at the time. They got talking, one thing led to another, and Amy saw something in Gail and Gail's story that led to her working with Adam Dudding and putting together the Gone Fishing podcast, which took a couple of years to pull together, from what I understand.
So that's extraordinary too. So you're saying that the journalist who put it together, the podcast, was actually in jail, and that's how it all started, because she ended up as a cellmate or a colleague of Gail Maney.
No, I quickly need to dispel that. She was there working as a journalist.
And, they're working as a journalist.
Yeah,
met her.
Yeah, correct.
Okay.
Correct.
Oh, sorry, it just didn't come across that way, but just as well we clarified that.
Yeah.
All right, because that would have been a story all of its own. All right, now, so the podcast goes out in 2018. That's fine. It did very well for itself, as I remember. I remember a number of people mentioning it to me at the time. They read it and go, "Oh my God, what a story!" And they should make a movie of this. But then, how did you get involved, though, Tim?
So on the back of the work I'd done on Taina Porter's case, and I'd started working on the Ellen Hall case at that time as well, Amy got in touch with me. They wanted somebody who had done this sort of work to provide some, it's not how they couched it, but it was relatively superficial comment on the types of things you see in wrongful conviction cases. So I had a short cameo in the podcast itself in one of the episodes. I think probably as a counterbalance to another ex-cop who came on and said it all looks clean and tidy to me. And so I on the back of that, I had a closer look at the case, and I had a look at some of the facts, and I was pretty curious about it. There were some real red flags, and Amy introduced me to both Adam and eventually to Gail. Gail and I got on quite well when we spoke, and before long she'd asked me to help get another lawyer and have another crack at her case.
Okay. She'd always protested her innocence. I think the first trial was held in March 1999 at the High Court. All four of the accused pleaded not guilty. I think they were all found guilty. But then I think there was a subsequent case in 2000, a year later, and then 2005, 2007, as they kept on appealing aspects of their case through the judicial process. They were all unsuccessful. Did you go back and have a look over those cases and try to come out to why the courts decided that they were guilty?
We did, absolutely we did. And so there was so the first trial was in 99. All four were convicted. There was an attempt by three of them to appeal after that 99 conviction, and Gail and Mark Henriksen were successful in getting leave to appeal. Stephen Stone couldn't even get legal aid to appeal, so he was denied the opportunity to even lodge an appeal at that early stage, which was outrageous when you think back as to what's occurred. So Mark and Gail were successful in their appeal, and they got a retrial ordered, and that was the second trial in 2000. But of course, that trial was frustrated by the fact that Stephen's conviction remained. And so far as the jury and the Crown were concerned, there had been a murder in Larnock Road. Dean Fuller Sands had been murdered. And so the defence had to work around that, which was difficult because Gail's position was and always has been, and is one I believe, that there was no shooting in the garage. Nothing of the sort ever happened. But she couldn't run a defence like that because there was a conviction in the way.
Really? And there was also something else that stunned me, that the judge, who I think was in charge of the 99 or 2000 case, you'll be able to tell me, ended up on the Court of Appeal hearing her appeal. Is that right?
So on the 99 trial, the judge made an error in the summing up to the jury,
Yep.
and wasn't particularly favourable to Gail and Mark Henriksen. Correct. He then later appeared in the 2005 appeal as one of the three judges on the bench, deciding whether or not the appeal should be granted.
That's extraordinary. I mean, extraordinary incompetence, but I mean, it's so obviously a conflict of interest that, I mean, how did that happen?
Well, this is one of the things. There are many things that we think need to be looked at by an inquiry, but I'm given an assurance by different people that that wouldn't happen now, but it should never have happened then. I don't know how you can justify
Yeah.
that.
Yeah, that's just, oh, listen, it's typical bloody judiciary covering up after themselves, quite frankly. It's one of the reasons New Zealand have lost faith in the justice system. Judges covering each other's backs. Listen, going further on to this, though, all right, so you get involved in 2018, you start to investigate, and a whole series of things come out of there. The name of Detective Inspector Mark Franklin now becomes prominent. He's the man who led the police investigation. But he's an odd piece of work himself. Can you explain and introduce us to him, please?
So Mark was a pretty high-profile senior detective in West Auckland through the 90s and early 2000s. He's a character that's larger than life. Curiously, he decided it would be a good idea to go on the podcast.
Yeah, so
And so people that haven't heard the podcast, if you go and listen to the various episodes, Mark's in there defending his work, and you get a sense of the character and what he's like. He has some interesting takes on things, but it is undoubtedly true that he was the driving force in this case.
Now, when you say larger than life, well, he ends up getting imprisoned in Rarotonga for drug dealing, which is extraordinary of itself. Did he have a drug problem that you think affected his judgment during the course of this investigation and subsequent trials?
Well, I don't know because I haven't asked him, and I've seen nothing to confirm that. But what I would say is there are some very strange things and decisions and theories that emerged in the early days of this inquiry that suggest to me that the person leading the inquiry wasn't always clear thinking.
But nonetheless, one would presume that the police as an organisation clearly backed him and his judgment. Otherwise, they wouldn't have prosecuted or taken that particular view. There must be more than just... So, I mean, even if we start to say that Mark Franklin went rogue here, and his role is odd, strange, and he's one of the reasons why the Court of Appeal, or almost a primary reason why the Court of Appeal quashed the convictions last year, surely there must be other police who managed him that had the oversights of these cases, particularly as it's going through appeal processes, plural, and gone, they must be held accountable too, surely.
Well, I think that's an important point. What is the supervision? How does a case like this, that is so disturbing and so flawed, make it all the way through to the point where, up until yesterday, the Crown was still contemplating continuing with the prosecution in relation to the evidence they collected? So one of the things that I get sick of hearing in these cases is that it wouldn't happen now. But that contrasts with the position that the Crown and the police often take in these miscarriage cases, where they continue to defend what has occurred. And that's in large part, not entirely, but in large part what has occurred here. There is the suggestion that some of the evidence that was collected was credible, and in our view, it never was. And the fact that supervisors and prosecutors failed repeatedly to identify the scale and nature of the issues is deeply troubling.
The reason why there was a prosecution and it all hinged on 4 witnesses to the murders. Now, just for the people who haven't caught up with this, the police didn't make this up. Well, they might have made it up, but what I'm saying to you is, if you're a jury listening to the case, although there was no body of Dean Fuller Sanders and nothing in DNA to link any of the defendants to either of the victims, 4 witnesses, 2 male, 2 female, claim to have witnessed the murders, and plural, and they, in one particular case, all given immunity for prosecution, but in one particular case were repatriated overseas under the witness protection scheme. Now, that would have been, if I was sitting on a jury, pretty compelling evidence that 4 people turn up in at a court trial and say, yeah, I saw it, I was there. How did that occur?
Well, if you accept the witnesses that have since recanted, they were, and not only their evidence, but Gale's as well, they were bullied, threatened, and induced into saying what they did.